Good morning, this is Rahul Reddy. Today we have live session on H1B. If you're selected in the lottery, not selected in the lottery, what are the options that are there? Along with me is my business partner, Emily Neumann and Stephen Brown. Emily, what are we discussing today?
So we want to talk about the lottery that we started getting results over the weekend, how long we're expecting to continue to get results for, what we're seeing in terms of percentage of selection, when we think this is going to end, when is the filing window, when is cap gap. We're going to talk about filing for dependents. Should you do consular processing? Should you do a change of status? And of course, answer your questions. So that's kind of our plan for today, is just to kind of give you a path forward for what happens next.
Stephen, how many people got selected in the lottery? You are the head of the H1B non-immigration department and the litigation, of course. How much percentage of the people got selected, though?
Yeah, I mean, right now, my desk, I'm sitting at 17%. I'm still waiting for feedback from other attorneys in our department. I know Emily was a little bit lower, but she has a smaller sample size, but I'm at 17%. I'm kind of expecting it to be around 15% this year.
Okay. And do you think so the selection process is over, or do you think so it's going to continue until the end of this week?
I don't think it'll go to the end of this week, but until USCIS announces that they've done the lottery and uploaded everything, we could still see selection notices. I will say I checked it last night around 7 o'clock Central Time. And this morning when I first came in, I had no new notices between that time. So perhaps we're getting to the tail end of it. But again, we still haven't seen the announcement from USCIS yet.
Do we have a number of people who applied for the H1B lottery? Do we know, or we don't? And how many people in the masters, how many people in bachelors?
We don't know, but I have some predictions. I mean, if we're looking at 17% of cases getting selected, and that's kind of what we're seeing from other attorneys outside our firm. Last year they did announce that they selected 127,600 registrations to meet the 85,000 cap. So assuming that they're going to do the same thing this year and select 127,600, if we're at a 17% selection rate, that would suggest 750,000 registrations this year, which would not surprise me given all of these duplicates that we're hearing about, companies filing with other companies for the same set of people. I mean, we've been seeing those notice of intent to revoke from last year's lottery where they're listing out this company filed, registrations for 50 people, and then 5 other companies are named that did the exact same thing for those same 50 people. I would expect, because nobody's really been getting caught doing that yet, that we're probably going to see even more of that this year. Now, Stephen, you did a FOIA request, right? What are we thinking will happen there?
That we're going to have to sue to get the FOIA. I did file a FOIA request last Tuesday after the lottery ended, requesting all this data, kind of the numbers from companies and how many duplicate filings and similar passport numbers were used. And we'll see what they give us versus what's they take privilege on, especially with passport numbers, but we will have to wait for that data. And if I can add, Emily, what you're saying, there's a lot of factors that would lead to it being a higher number this year, with a potential for an increase in fee. I know there are companies who are filing more this year. Maybe they wait till they're in their STEM OPT to file for them. Now they're doing it at that OPT stage. There's just, I think you're right. I think we're going to see a much larger number. And we're hearing 10% from some law firms that we know, and 5%, and so it's we'll see where it ends up.
So are there any fraud preventive methods USCS have taken? Are we aware of anything, Emily and Stephen?
No, I mean, so their method of fraud prevention is to increase the attestations that the employer has to agree to when they submit their registration, basically saying that they agree that they did not coordinate with other companies, that this is not a duplicate filing, that they have a bona fide job offer, and all of those things. but it's all the honor system. USCIS has no way of going back and verifying those things from March 20th, the date the lottery ended, through March 27th, the date they complete the registration selection process. There's no vetting done during any of that. The vetting happens after the petitions are selected, after the petitions are filed, after they're even approved, and then they start doing site visits. Then the consulate starts doing their fraud detection, and then we start to see notice of intent to revoke. But that does nothing to help the people that didn't get selected because other people gamed the system.
And the ones that are getting caught, Emily, could be on your local radio's dumb crook news. I mean, if they're trying to be sneaky, they're being very bad at being sneaky. So they're not catching the people that are more sophisticated in going about this process of gaming the system.
So, Stephen, if I get selected in the lottery, explain the process. So, you receive an email, or is it when you log in, you get it? And once I'm selected in the lottery, what's the process the company and lawyers do to file the H-1B?
Yeah, so you as the individual have no way to check this out unless you go to your attorney or the company. Both of them can get the selection notices through their My USCIS account. For Reddy and Neumann clients, we are working today to get as many of them uploaded into our system and in our firm's Liberty portal, and you'll see registrations selected. Or again, like I said, talk to your employer. Once the process begins here, you can start filing the LCA, the labor condition application, saying where that individual is going to work, what their job title is, and what their salary is going to be. That takes about 7 days to get certified by the Department of Labor. And during that time, you can work on preparing the forms for USCIS, the I-129, and you can file it. So you'll have a filing window of April 1st to June 30th. Do not file before that, and do not file after that. USCIS is very strict. If it's on July 1st because there was a rainstorm that slowed down FedEx, I've never seen them forgive that. So get it in early and get it in right. And then one thing to mention is, even if your company didn't use an attorney during the registration process, the registration process is not the most complicated. A lot of companies do it on their own. You can still use an attorney now at the filing stage to file the petition.
And you said that LCA need to be filed, and they need to file the application between April 1st and April 30th. What's the role of the employer? What's the role of employee? What's the role of lawyer in this filing the application?
So, I mean, every law firm in business is going to be different. For us, we tend to work directly with the employer and the employee, because obviously we're going to have to get your information and know your immigration background in order to properly file this. So we'll get a bunch of documents from you as the individual, so we can prepare the forms and prepare the supporting documentation. But it'll be a lot of back and forth. The company will be the one signing. You as the individual don't have to sign anything. Just make sure you're getting those documents to your employer or to their attorney. Emily, you were saying something.
Yeah, so I know you mentioned the filing window is April 1st to June 30th, but does that change for someone who is needing CAP-GAP, because their STEM OPT or their OPT is expiring before June 30th?
Yeah, absolutely. So CAP-GAP, for those of you that are on OPT or STEM OPT that is expiring, if you were selected in the lottery, you could qualify for CAP-GAP by filing a petition to USCIS for a change of status. And I want to emphasize a couple things. One, the selection notice isn't anything. That does not get you CAP-GAP. It has to be the filing of a petition. That has to be done before your OPT expires. It has to be to USCIS before your OPT expires, and then you can get that work authorization until September 30th. And again, you have to file for a change of status. So don't consular process if you're trying to get CAP-GAP.
With regards to the consular processing, Emily, some of the companies, even if the individual is an F1 student visa here, and sometimes some of these students, to save money on the taxes, because Social Security taxes or Social Security is not deducted from the F1 students, they choose to do the consular processing. Do you suggest that, or do you suggest applying for change of status?
Yeah, I generally don't recommend consular processing for those that are in the U.S., particularly those that are on the F1 that have the OPT, as a way to, yeah, you might be saving on taxes, but it's really important to know that the consular processing approval is technically not counting you in the H-1B lottery, in the cap. So if you get that consular processing approval, and the only way to activate that H-1B is for you to exit, apply for the visa at the consulate, and come back. But what happens if you lose that job before you've gotten a chance to apply for that visa? That means that you are not counted in the cap, and you have to go through this whole lottery process again. So a lot of the companies I feel that are pushing consular processing on those that are inside the US are doing it for the company's own benefit, because when you have a consular processing approval, you can't take that to another employer. So that's helping the company keep you. Whereas change of status, once that change of status is approved and takes effect October 1st, you technically could transfer to another employer without having to go through this lottery again. So just think about, from your personal standpoint, what is the benefit to you of consular processing? It's usually quite low, and the employer is the one that's benefiting more. So it makes more sense and is better for the individual employee to do the change of status when you're eligible. Of course, you have to be properly maintaining your status, and your status needs to last through at least September 30th to qualify. The only people I would say maybe not do the change of status and instead choose consular processing are those that are switching from L1 to H1. Especially where your L1 is with a different employer than the H-1B that you got selected for. Because a lot of times we see when you get the change of status starting on October 1st, people want to continue working for their L1 employer and choose when to join the new employer. But technically you can't do that after October 1st, because you're no longer in L1 status. You're not authorized to work for that employer anymore. And I think a lot of people aren't aware of that and keep working for the L employer, and technically that's not proper employment authorization. But other than that, most people who are in the US should be doing a change of status. Another caveat would be if you've got travel plans. If you travel outside the US while the change of status request is pending, it will be automatically abandoned. So it kind of defeats the purpose of filing the change of status. So plan your travel accordingly. It's very possible that you could travel in April or May, come back, and then file your change of status in early June. That would be fine. Or you file your change of status in April, get it approved in May, and then you travel in June. That's also fine, assuming that you have the right visa to come back on. But traveling while the change of status is pending will cause that to be abandoned. You'll be converted to consular processing and then not counted in the cap until you get that visa stamp.
Emily, with regards to the people who are married, do we recommend filing the H4 right now, or wait until the H1B is approved, or not do anything at all?
Yeah.
For example, if I'm an F1, my wife is an F2, or probably some other visas with the B1 or B2, whatever those visas they may be. What do you recommend to them?
Yeah, number one, be aware that nothing happens to your dependent status automatically. So just because you are filing a change of status to H-1B, your dependent status does not automatically change to H-4. So if you're needing to change your dependent status to H-4 because they're on a dependent status right now, like an F2 or an L2 or something like that, we do recommend filing the H-4 change of status along with the H-1B, because you get the processing of both of those applications bundled together. They'll be processed together. They'll have the same start date and the same end date. You could choose to wait until October 1st or the end of September to file that change of status. Or if you have travel plans for your dependents, they could choose to just apply for the visa at the consulate instead. So there are other options, but most people find it best to file the H-4 along with the H-1 and do the change of status at the same time.
And if I can add, the reason to do it together is you're not going to forget it. And I think Emily Rahul and I see this every year. It's November, and someone's like, "Oh my gosh, I forgot to file an H-4. What do I do?" So just file it now would be my recommendation.
Stephen, question to you that comes from Sindhu BM. She's asking the question is, would there be a second round of selection this year?
We have no way of knowing right now.
Can you explain the history of the second round, please?
So 2020 was the first year of this pre-registration system. So there's a filing window of April 1st to June 30th. After June 30th, if there are not enough petitions filed to meet the 85,000 visas, then they will run a second round of lottery. So in 2020, they ran 2 rounds. In 2021, they ended up running 3 rounds, one in July, the second one in July, and I think I'd like to say October-November timeframe for the third one because there weren't enough. And then last year, there was not a second lottery. This is something that's going to just kind of catch lawyers, employers, everybody by surprise because there's no way to know this information ahead of time until USCIS announces there's going to be a second lottery.
And even with that, they don't announce it. They just start selection notices.
That's right. That's right. We just found it in our selection note. We got those emails.
Emily, the main question that is coming is that when you extrapolate the 17% to 85,000 though, the total is not adding up to 750,000. And of course, the master's quota is there. So can you explain how you're extrapolating? It's not coming out to 750.
Yeah. So first of all, yes, there are 85,000 visas, but to get to 85,000 approvals, USCIS selects more than 85,000 registrations. So last year, they actually gave us the data and said in order to get 85,000 approved H-1B visas, they had to select 127,600 registrations. That accounts for duplicates that get selected where the beneficiary only files with one company. That accounts for those that file and then get denied. And that accounts for those that file and then get withdrawn because they've left the company or their job was terminated. And even those that later get revoked. So they actually select way more than 85,000. So that's how I'm doing my calculation, is assuming that they ended up correctly with 85,000 approvals last year due to selecting 127,000 registrations. If we assume that, again, they are going to select 127,000 registrations, and we're only seeing a 17% selection rate right now, that equals 750,000 registrations, which I think may actually be accurate.
And that's just a lot of assumptions, right? So when it's less than 750 or more, don't hold us to it. It's just some educated math there.
Stephen, you came up with the 17% from your desk, and you're still waiting for your colleagues that you supervise. With regards to the selection, though, have you seen? I know that on Friday evening you came up with some percentage. Now, are you telling that nothing got selected after Friday evening? Can you be a little bit more specific on that?
No. Most of ours came in after Friday. In fact, I think most of them came in Saturday and Sunday, to be honest with you. I was at like 0.06% on Friday when I left. Got more Saturday, and it felt like over the weekend, every time I logged into my USCIS account, there were more selection notices than before until this morning when I haven't had any new ones.
So are you telling that at least from your files, though, from today morning, that's Monday morning, you haven't seen any new selections?
I have not seen any new ones since Sunday evening until Monday morning. That's not to say there's not more coming throughout the day today, but I have not seen any new ones.
Because Emily, the 750K, I just want to tell the audiences that we will change that if we see more selections. This is just the data from our office. It doesn't mean that, it's a whole data. And if more selections will come in, of course, it's not going to be 750, it's going to be less though. I want to answer the question from Srinu Reddy from Facebook. Why is the USCS not taking actions on individuals who are doing multiple registrations? Srinu, they are. The only thing is that we can't put them on this YouTube who are the victims of this multiple filings though. Every single day, I get consultations, I get contacts from the people who have been victimized or who have been troubled because either they supported the duplicate filing or their employer did it, but they got big sufferings. Their H-1B gets revoked at a later date. Every single day it happens. But the only problem is, Srinu, they don't come and announce in the Facebook. You know that a lot of people who get selected in the lottery, yes, I got selected. They tell everybody, but when they get their H-1B revoked, then they're kicked out of the country though. They don't speak, they just slightly slid away. And also, when the USCIS takes action, surprisingly, the bad thing is that they take about 2 to 3 years to take the action. So if somebody gets selected from a bad company, that you know what that means, I don't have to explain that. They don't have a job, they just file a H-1B, you got the lottery, you move your project to them only because they got the lottery. And of course, your real employer filed H-1B. So what happens to this company is that they have filed for a lot of people. The USCIS will come, the ICE, Immigration Customs Enforcement, will come to them and they will try to revoke the H-1B. Now, you may have moved out to Microsoft, you may have moved out to Apple though. They're going to still revoke the Microsoft and Apple at a later date because your first H-1B lottery is fraudulently filed. This happens, we do get a lot of consultations.
I want to address a question, Sheldon from Facebook. Can we expect some lawsuits to challenge the USCIS for the rig system? There were some employers that tried this, suing last year, I think it was, Emily, last summer, over the system, and the case got dismissed. When it comes to this system, it would have to be, USCIS did contemplate the fraud in their regulation, and essentially what they admitted in the case is we're just not good at it. We're not good at detecting it. And unfortunately, under the Administrative Procedure Act, the fact that they contemplated that when they created the new regulation on the registration, that's sufficient from a legal standard. Not being good at it isn't enough. I'm curious to see with the proposed rule. There is a proposed rule to increase the filing fee if there was a lot of feedback on the fraud or the perceived fraud on this issue, if they're going to try to push more. But right now, I don't think a lawsuit's viable because it got dismissed out of court pretty quickly last year. Same issue.
Now, Emily, can you discuss about the options for the people who are not got selected in the lottery? And most probably they are either on F1 visa or probably L1 or probably H4. Can you explain what are their options? Specifically, what about F1 visas? So they may not have a way out.
Yeah, so Steve and I are going to be doing a separate live stream on that next week, April 6th, if I recall.
I had to look it up, yes.
We'll be posting that info, and so we'll go a lot more into detail there. But quickly here, so if you are on F1 and your H-1B is not selected, of course, you can continue your F1 stay. You can continue your OPT. So if you are in your first year of OPT and you've got the STEM degree and your employer uses E-Verify, you are eligible for that STEM extension to get you 2 additional years so that you can try again in the future. If you're eligible for some other visa category, maybe your spouse is on H-1B and you are ending your F1, you don't have the ability to continue to extend your OPT, you could change your status to H4. As a dependent, of course, H4s can't work unless they get the H4 EAD, which requires the H-1B holder to have an approved I-140. But we see many people converting from F1 to H4 EAD if they're not selected. And one thing I want to point out is especially if you're applying in the master's cap, if you decide to exit the U.S., you've run out of your OPT time, you've run out of your STEM time, you're at the end, you can exit the U.S. and you can still file next year. You just need an employer, of course, to do that. But you still can go in the master's cap. I think a lot of people think that you can only file in the master's cap if you're in F1 status at the time. but you can do that anytime in the future. So there's always the option to come back in the future if you're selected. And of course, if you are at the end of your F1, you do have the option to continue your studies by starting a new program. There's a lot of people that talk about day one CPT schools that allow you to basically practically not attend classes and just work full time. ICE refers to these as pay to play schools. We are not fans of these schools. They cause a lot of issues in the future for people when they travel or go for visa stamping or file a change of status. So we don't recommend that, but you can, if you want to continue your studies at a legitimate school, you can do that and look into the options for employment authorization with those schools in line with what most normal schools allow.
If you're not got selected in the lottery though, and if you know some of the companies who have filed multiple filings without the job though, you can report the abuse of the lottery system. There is an email that allows you to do so directly to USCIS. I'm going to put that email address. It's called report H1B abuse at uscis.dhs.gov. I put a link in a website, guys, that gives the directions how to contact the USCIS and report any of the fraudulent activities done by the company.
There was a question from Naresh on Facebook. I think it's important to distinguish what we're talking about, these duplicate filings. And Naresh's question is, if I get a job from Apple and a job from Microsoft and they're good candidates and they apply to me, is this considered duplicate? I think that's a proper thing, right? You're a great candidate. We would expect, someone coming out of college that's a tremendous applicant to have multiple real job offers. The problem and what we're referring to is that there are companies that'll see someone and there's not real job offers. These are, hey, I'll register with company A, and then company A is going to talk to company B, C, D to also register for me. I don't really have job offers from B, C, and D, but they're going to work together to make sure I'm selected and everybody gets a cut when it comes through here. Again, if you're Microsoft, Apple, Meta, and all that, because you graduated MIT, top of your class, like, great. I think that's fine. I think the problem is when it's buddies that are getting together and trying to rig the system without real job offers. Emily, thoughts on that?
Yeah, I think that, a lot of people suggest that, well, why don't we just go by the passport number and the beneficiary only gets one time to enter into the lottery, which I'm not against, but that does limit that beneficiary's ability to, if they truly do, if they truly are a great candidate and have these multiple legitimate offers, maybe we want them to have multiple attempts in the lottery so that they have a better chance of getting selected. And that's the difficulty of going to just, you only get one chance for everybody, because it stops kind of the cream of the crop from being able to do that. And at the same time, if we make it, other people are saying, okay, well, let's do one beneficiary. And then once they're selected, they can choose the company that they file with. Sounds like a good idea, but that is completely opposite of the whole H-1B system, because it's all petitioner based. It's all run by the company. You have to have the job first and then be sponsored. So if you are the beneficiary and you're submitting your own name into this lottery with no job at all, and then you get selected and then you go to employers and say, hey, I was selected, will you file for me? I think that's very counter to how the whole H-1B system is. Maybe that's what we should be doing. I think Canada does something similar to that, where you can get a work permit first and then you find the job. But that's just not how our system is set up. So I don't see that happening. What I would love to see happen, and Raul came up with this idea, is each company, when they submit their registrations, they have to provide their bank account information, and all of the filing fees should be automatically deducted for every single selection that gets that they get. I think that would cut down on the fraud, because obviously those filing fees are quite expensive. Having this $10 fee is just so ridiculous. Even increasing it to $215, that's not going to do anything, because the companies that are gaming the system are just passing it on to the employees. They're not even employees; they're beneficiaries. They're the candidates, and so going from $10 to $215, I don't see that stopping anybody. But if everyone had to pay full filing fees like they did in the old system when we had to file the petitions with filing fee checks, that did help cut down a lot of the fraud, I think.
And the filing
you misquoted me, Emily, in one thing which I want to correct, though. I said that every person the company is filing, the money has to be deducted first. And then if they are not selected in the lottery, the money would be given back to them.
Like, keep it in escrow.
Yeah, keep it in the escrow. That's the way I said. But that's fine.
I think we can see the difference. I mean, Emily, we used to get the statistics, and I know you've got your board there, but pre-2020, we didn't see 750,000 petitions because it was the full petition and the full filing fees. So
yeah,
it's
I mean, the maximum was 236,000 back in April 2016. Prior to that, it was well, I take that back. It was 236,000 was the highest number we saw when you had to file the full petition.
Yeah, this definitely is there. So when is the session that you said, Emily, you and Stephen are doing? If I'm not selected in the lottery, would you post it on the Facebook and also in the link in the YouTube underneath this one, please?
Yes, this is going to be on April 6th. We don't have the link ready yet, but we will be posting it on our social media. So keep an eye out for that so that we can answer questions about options for those that aren't selected. Because we know that it's going to take time for attorneys and companies to notify people who got selected and who didn't. So we want to make sure you know for sure that you were not selected before we run that live stream. Sam from YouTube asked, has anyone got selected this morning? Is USCS still sending notices? From Stephen and I've not gotten any selections today. I actually didn't get any yesterday either. But Stephen did and others on our team did, but I'm not aware of any coming in today. I have a feeling today is it. I think we'll get an announcement later today saying that the lottery was conducted and all selections have been uploaded. That happened last year on March 26th. So we're at March 27th, which is the Monday following all of the selection notices being uploaded. So that's my guess. Again, you can't hold me to it, but that's just based on looking into my crystal ball based on prior years. And again, the 750,000 potential registrations is just based on some quick math of what we're seeing right now. Hopefully we'll see more selections come through, but if we don't, we should be getting the announcement. And I think in that announcement last year, they did at least tell us how many total registrations there were. But they did not last year at this time tell us how many they actually selected. I don't think that happened until September or August, if I recall. They didn't give us that 127,000 number.
Yeah, I think it was after like all the cases were done and then filed. And that brings a good point, the salary-based selection. That was a question. That was a proposed regulation in what, 2019? Or 2021, I feel like, or 2020. Anyway, sometime in there was a proposed regulation to run, I called it power ranking, right? The higher your wage level, the better chance you had selected. That's a fine, that's one way to cut down on these issues. That got taken out of from court, if I remember right, Emily, correct? There were lawsuits by nonprofits and smaller hospitals that got rid of, that sued to get rid of.
Yeah, and then people need to understand that 90% of the research in the world happens in this country. And if we are going to put only based on salary alone, we may cut down the researchers, which actually they don't get highly paid compared to the IT professionals. So that could be a big discouragement for the research organizations too.
Yeah, and how would you even enforce that? Again, when we're filing the petition and, some company could say, yeah, I'm going to pay this person $200,000 so that I have a better chance of getting them selected in the lottery. They get selected, they file the petition, they get the approval. It's 6 months before they have to actually start paying that salary. the issue is not going to come up until it's time to file the extension 3 years later. And then USCIS might say, oh, wait, we see that you were only paid $100,000 for the last 3 years. Now we're going to go back and revoke it. So it's an interesting idea, but again, it lacks teeth. There's no way to enforce it to actually ensure that.
Especially since it's a future job, starting in October when you're filing in April. And like I said, it was hospitals and nonprofits that pushed back more than anything.
Anything else to discuss, Emily?
I think we got through everything we wanted to talk about. So again, hopefully we will get a notification from USCIS later today, letting us know that they've received however many registrations and that they've completed the process. That's my guess that it will happen sometime today. That'll give us a better sense of kind of what the selection rate actually is. And if you are selected, now's the time to start working with your employer to file between April 1st and June 30th. Again, we don't recommend waiting until the very end to file in case there's some sort of delay with getting it received by the Immigration Service. That is a hard deadline. And if you're needing the cap gap to extend your OPT or STEM OPT, make sure that you file the petition before your OPT expires. The June 30th is not your deadline. Yours may be earlier. Don't forget to file for your dependents and consider filing a change of status if you're in the U.S. I think that the potential tax savings versus being sure you're actually counted in the cap, the being counted in the cap very much outweighs any slight savings you may get on your taxes.
Thank you very much for tuning in.